The information found in this video and related presentation is provided by the Retirement Research Foundation and is for educational and informational purposes only. Nothing in this video should be considered to be tax or investment advice. Welcome. Thanks for joining me here at the Retirement Research Foundation. I'm Daniel Rondberg, and with me is Ben Skinner from Taylor Skinner Law. Ben, so glad to have you here today. I heard a story that broke my heart the other day. I had a lady in my office. She came up to me and she said, hey, you know, Grandma and Grandpa had this big estate, and she wasn't expecting anything, but her dad passed away. Mm-hmm. And when Grandma and Grandpa died, no money for her.
Okay.
And she's going, why did Grandma and Grandpa disinherit me? What did I do? What could have happened? I mean, I already lost my dad. They're grieving. Could that have been solved? I mean, maybe Grandma and Grandpa fully intended for her share to be paid, you know what I mean? And there's this per Stirpes designation that could be important there that I don't think people are actually talking about or using enough of. And I don't think people understand what would happen if they were to lose one of their beneficiaries before then.
Yeah, and I just real quick to define that term. So I went to law school at a time when there was a really strong movement away from using the Latin phrases. We want to use plain English, plain language, and try to be able to explain things to our clients in a way that just makes perfect sense to them. So
I love it.
What Daniel's referring to is there's two things that can happen. So if I name my four kids in my will and I say when both my wife and I pass away, I want my four kids to get whatever's left of our estate equally. But then you always have to decide what would happen if, and I always hate to ask clients this question because it's an uncomfortable question. What would happen if one of your kids passes away before you? What happens to their share?
Yeah.
But
it's an important question.
Oh, it's vital. It's vital.
Yeah.
And you've got to, and it has to be explained to them. And I think a lot of, certainly not document preparers don't explain this because they can't give legal advice. And many attorneys don't even take the time to explain this distinction. So what happens if one of my sons passes away first? What happens to their share? Well, most people, there's no right or wrong here, but there's two options. One is it can flow down to their children. Now, first of all, spouses don't ever have a right to inherit.
Always through the bloodline.
It's always, it's through legal. It could be bloodline or they could be legally adopted. So legal, the term we use in the documents is issue. My issue are my biological children and my adopted children. Those are my issue, or grandchildren on down the line. So if I say I want it to just go to the survivors of my children, that means it would stay in their generation. That's what happened with your friend.
Yeah.
The grandchild is her grandparents must have decided that when her father passed away in the documents that his share went to the other surviving children. So that's the choice. Is does it go to the survivors or survivor, however many are left, or does it flow down to the issue? And there's no right or wrong on that. I mean, I always tell people those are the options. If you have a relationship with your grandkids and you want your grandkids to be provided for, then you want to say to their issue.
Right. And that could have been maybe misunderstood. Maybe they thought it was going to flow down.
Yes.
And it didn't because you didn't have that per Stirpes or that to the issue designation. It's one of the things I love about you, Ben, is you don't speak in legalese. I think that's not the right term, but I mean, it is kind of confusing when you have all these Latin definitions, all these old world
we
legal
try to stay away from those as much
as
possible nowadays. Yeah.
So people could put per Stirpes designations on their life insurance, their annuities, their IRAs, their whatever account to make sure if they're not using a trust, going through per issue for their asset distribution.
Good, and maybe let's talk through that for a minute. So if you have an annuity, that, for instance, and so you would set up as the beneficiary, your primary beneficiary is your spouse. Typically, if I'm the owner of the product, it's usually the spouse. Yeah. And then you're talking about the contingent beneficiaries.
The contingents, that contingent section you could name.
Yeah, and I think on the beneficiaries, it's very common for people just to say my kids. And if you said just my kids, then that would not flow down to their issue.
Right, that happens all the time.
Yeah, so you have to designate.
You have to take that extra step to ask, hey, this is a good follow-up. Check with your situation to see is that important to me, and do I need per Stirpes designations on my financial products?
Exactly.